Hello, and welcome to our training on the role of the justice system in petitioning in the CARE Act process. Today, we're going to talk about a few items to help you feel more confident in the petitioning process for the CARE Act. So our discussion will be broken up into two sections. The first section will be an overview of CARE, including the purpose, who it helps, and why, and then an overview of the CARE process, eligibility, petitioning, really focusing on the high-level details. The second system, we're going to hear from justice partners on the ground, details for those partners to support CARE petitioning, and provide recommendations for justice system partners engaging in the CARE petitioning process. We have a few learning objectives today. The goal isn't that you can have everything you need, but to point you to the high-level learnings and point you for additional resources so that you can feel confident in taking the next step. So our goal is for you to be able to identify unique aspects of care, including the different paths through care and the range of services that could be included, and also describe the role of the justice system as petitioners in the CARE Act process. So we are joined by a number of panelists. So in a moment, we're going to turn to a live discussion that was had between these different groups. So we have Dr. Deborah Rose and Dari Pogash from Health Management Associates, who will run you through that first section, which is an overview of care, touching on eligibility and how petitioners are involved. And then we'll be hearing from a few system partners on the ground, including Honorable Ibrahim Beytai from Orange County Superior Court, and then Raul Dominguez, who is works in Stanislaus and who has worked in both probation and is working in care. And we'll hear from them about lessons on the ground in how to make care more successful. So with that introduction, we're now going to turn to that live discussion.
What is the CARE Act? Taking a big picture perspective of the CARE Act, it's a civil court process, and it was really designed to be an early upstream intervention that focuses on recovery and autonomy for people living with serious mental illness. And often that means that we're working with folks who have a history or at risk of homelessness, a history or at risk of justice involvement, because as a result of lack of access to treatment or an unwillingness to engage in treatment, these folks end up vulnerable and marginalized. And so our goal through CARE is to help provide services and supports as soon as possible to the individual personalized needs. You'll see on the left of the screen that we refer to many paths in. So there are a few ways that people can become connected to CARE. Certainly, there are multiple petitioners. It all begins when somebody, perhaps someone like you, files a petition on behalf of an individual who you think might benefit from CARE support services. Either it's a petitioner through the community, a professional or other, and we're going to talk about that more, or petitioning through the county behavioral health agency of your county. You'll also see that in the process, in towards the middle of the screen, this is really about connecting with people either through voluntary engagement, voluntary care agreement, or a care plan. Again, I'll talk to each of those in more detail. It's all about connecting people to services. Paths out means that there are a few ways that the care process may end through graduation, or again, through that voluntary connection to services. Really important to note, though, that it doesn't end with a graduation. Services continue in the community. Somebody's doing well. We want to see that that kind of collaboration and assertive community supports can remain available for that individual. So again, this CARE process is about identifying services, connecting people to services, and providing them the opportunity to engage with services. There are a number of links at the bottom of your screen. I'll say that a couple times, but you'll see them throughout the presentation. And for each of those links, if you'd like more information, you can really look at them in detail and look at our training that goes with those details. Links are available to you. So how can CARE help? What are we talking about? Why would we consider CARE for a person? There are a lot of buckets on this screen. I'll probably talk through them in no particular order. Really, it's about ensuring that we can use a trauma-informed approach, considering how to engage people in the community, meeting somebody where they're at, offering direct resources that might help engage somebody, and building up rapport and trust to identify that person in potential care services, and ultimately in the care agreement or a care petition process. Some of those services are really designed around a care coordination model so that people, it's all integrated and it's a comprehensive wraparound services, which means that it's not just one kind of service or support. There are multiple services and supports that are working together like a jigsaw puzzle to ensure that that person's needs are identified. Frequently, they're done by multidisciplinary teams, and that usually means an ACT team, assertive community treatment, which is like a clinic on wheels, a FSP team, full service partnership, which is very similar to an ACT model. Both of those models include psychiatrists, nurses, nurse practitioners, social workers, people with lived experience. And so they're designed to work with the individual to ensure comprehensive services in the community. It may also be a ECM or an enhanced care management through CalAIM, another kind of a multidisciplinary team. Frequently, care includes supportive housing, and those are resources that are built into a housing model to help people develop skills, may include medications. I've mentioned peer supports, and that's really a chance to have somebody with lived experience, personal experience of recovery, and they help mentor and share their personal experience in the form of coaching and support. Really a very big part in an efficient way, not an efficient, but an effective way to engage people. You've heard me talk about a care plan and a care agreement, so I'll mention those both now, but we'll get into them a bit more. A couple of other things that I think are important to note is that the CARE Act really does ask for a reinforcement of psychiatric advance directives. And so these are an opportunity for people to document what's important to them in times of recovery. Maybe it's, if I'm not doing well, who's going to take care of my pet or pay my rent? Maybe it's something like, I prefer this medication over that one, or I'd like this family member contacted. So it's a way of ensuring that people's needs, wish, preferences are available to all of the treatment providers who are involved in their care. A couple other things, which I think is really interesting, is that the CARE Act not only identifies services and holds an individual accountable to engage in those services, it also holds each county accountable to provide services that are identified. So here we're talking about a blending of ensuring that services are identified and are also provided for the individual. And then last, you'll see noted that care is really identified as a less restrictive alternative to conservatorship or to other more restrictive interventions. So that should give you a high level of what's hoped to accomplish, and let's go on. Thank you. We're going to talk a lot about the justice system, which means a whole lot of people as both petitioners, and then later we'll talk about you as being potential referral sources to care. Identifying a few of the folks who may be petitioners, meaning that you're identifying care eligible or potentially care eligible individuals, or healthcare providers that are working in custody settings or those that are justice impacted various ways. It could be individuals who are working in forensic healthcare settings, so doctors, nurses, others who are involved with an individual's care. Certainly the director of a carceral setting, and that also may be their designee. Or it could be people who are providing services within a carceral setting. First responders we talk about, and this could in this form include probation officers, parole officers, and others. And then important to note that we're also hearing that respondents, with the help of their attorney or the optional help of an attorney, have been petitioning the court on their own behalf to access services and to reach some of the services, including housing perhaps that we talked about earlier. Lots more information is available on the links below. Pardon me. So we've discussed who might be petitioners. Let's shift a little bit to where we may be thinking about people within our system who we can support through the care process. This is not linear. We've laid it out here to show you different points in time. And as you know, people are engaging with multiple points, perhaps at the same time. But some things that we can think about is what's happening in the community. When we have EMS involved, police, other first responders, perhaps crisis intervention teams, these individuals might be considered as identifying a potential care respondent, somebody who's seen, and these are people that you've worked with before often, you've had experience, you see where they're living, what they're looking like, how they're interacting with the community. Often these first responders are able to really identify somebody who might benefit from these intensive care wraparound services. Perhaps it's crisis stabilization centers where people are afforded the opportunity to be in a supportive environment. They frequent it often. Folks working in supportive crisis centers can also help identify a care respondent because they recognize that there's some needs that might be offered throughout the care process, or responding to those needs, I should say. We consider court proceedings, and we're going to talk about them at length in a moment. Certainly, respondent counsel and the court itself can discuss a care referral or a care petition with the individual. And we're going to talk about incompetent to stay on trial referrals in a moment, but that's an additional area. And the court, again, we'll talk in detail, but can also refer somebody to the behavioral health agency of their county to perhaps fill out a petition on behalf of the court and the individual. As we consider other places where there may be some interaction, certainly custody, I've talked about this a moment ago, and really when we're thinking about assessments post-booking, medical assessments, psych, social work evals, that's a great opportunity, nursing evals, that's a great opportunity to think about. This is somebody we know, we've seen this person before, we might think about this person for care, or this is somebody new to us, but based on what we are asking and the responses, let's again consider that person for a care referral or a care petition. And certainly when we're thinking about reentry planning or discharge planning, flagging care as a potential option for somebody who is reentering the community may be a great way to think about ensuring some continuity of care. And then for folks who are working on actual units or in pods, when you are considering observing somebody, how are they interacting with their peers? Somebody coming out of a cell, are they responding to internal stimuli? Are they requesting more psych services? These are folks that may say, oh, we have an opportunity to consider this person as well. And so certainly healthcare staff and custodial staff within a setting, a jail setting, might also be considering care. When we think about reentry planning, and I've just talked about that, making that referral to be part of a community transition back into the community, that's really where services can be identified and secured, especially if you have a known release date. And then perhaps not last, but last on this screen is post-incarceration supervision. And we're fortunate we have, my colleague is going to speak in a little bit and can talk about this more, what it means to be in the community, but thinking about probation or parole officers who are working with individuals who think that they might benefit from the additional services that can be afforded by care opportunities.
Since this training was originally recorded, the petition forms produced by the Judicial Council of California have been updated as of July 1st, 2025. So we wanted to just go over some of those changes and provide some general guidance about completing the petition. So the purpose of the petition, remember, is not to prove everything up front, but to give the judge enough information to decide whether the case should move forward. Based on what's submitted, the judge may either dismiss the petition or ask the county behavioral health agency to investigate further. The petition doesn't need to be exhaustive. It should include what you know and have observed and enough enough to reasonably believe the person may meet the care criteria. So there are two different ways to file a petition depending on who you are and what information you have. Regardless of which option makes sense for you, the petition will ask for information about the petitioner, information about the respondent, such as how to contact them and any language or accessibility accommodation that may be useful, and information about a court referral, if applicable. The bulk of these forms will focus on capturing information related to an individual's potential eligibility. So let's talk about these two options. So the first option that you see on the top is a general petition process that would make sense for most petitioners. You would use this path if you're not a licensed behavioral health professional, for example, family members or first responders. Step one would be to fill out the Care 100 form, which lets you explain your observations in your own words. And step two would be including one of the following to support that petition. So the Care 101 form. So this would be a declaration from a licensed behavioral health professional who's either examined the individual in the last 60 days or has tried multiple times. And they must believe the person may meet the care eligibility criteria. So the other option to accompany the Care 100 form is documentation. So this would be evidence that the person has had at least 2 intensive treatment, one within the last 60 days. So this could include hospital discharge papers or a signed declaration for someone with direct knowledge of those hospitalizations. So if the person completing the petition, the Care 100 form, has direct knowledge, the declaration of the 250/250s can be included directly on the Care 100 form. Otherwise, that information can be attached to the petition, like I mentioned, a hospital discharge paperwork, a declaration from a witness, or other evidence of those 250/250s. So that's option one. Option two is a streamlined process for licensed behavioral health professionals. So you would use this path if you are a licensed behavioral health professional, which can include members from county behavioral health agency. So for this option, you would only fill out the Care 102 form. This combines both the petition and the declaration from the licensed behavioral health professional into one document. Like the Care 100 and the Care 101, this Care 102 form allows you to describe what you've observed and why you believe the person may be eligible for care. Regardless of which option you use, the key is to provide enough detail for the judge to decide whether the case should proceed, not to prove everything. If the judge believes there's a reasonable basis, they may request more information or begin the formal care process. Just document what you know and keep the focus on what you've personally seen or learned. For more information about the mandatory forms, you can see the forms on the Judicial Council website, and there's many resources on the CARE Act resources for petitioners page, including additional tutorials and information for different petitioning groups.
So we've talked about meeting criteria, or maybe meets criteria. What are those criteria? Bunch of things here on your screen. First, it's an adult California resident, somebody 18 or older, who's living with a serious mental illness or mental health disorder, notably schizophrenia or schizophrenia spectrum or other psychotic disorders. That's important because there's some very specific diagnostic criteria in that. We're going to talk about it a little bit more. Needs to be severe and persistent. So the person has been living with this for a while and really is hasn't been engaged in voluntary services. Doesn't mean that the person can't be enrolled in services. Somebody can be in recovery services and still be eligible. Perhaps they're not engaged frequently enough, or it's ineffective what kind of services. So it's just about somebody who's not doing well and is not stabilized with the current services that they're receiving, or they haven't been receiving recovery or treatment services at all. Certainly, we think about care as the least restrictive alternative, and then the person should benefit from services, right? There should be a reason. This is work to design to help support an individual's recovery. In addition to that, at least one of two things need to be true. Either the person's unable to live safely in the community without the kind of wraparound supports and supervision, and that person, their physical or behavioral health presence is deteriorating. So either, again, not living safely in the community, or really an intervention is needed to prevent relapse or to prevent further deterioration. So all of the bullets on the top, and then one of the two bullets on the bottom. And once again, there's if you want to know more about eligibility, we have lots of information for you available in trainings and in briefs that you can take a look at, a one-pager on eligibility, so you can learn more after this webinar is over. Clinical and diagnostic eligibility that I just mentioned, there's a lot here on the screen. I'm going to simplify it, I hope. There are a number of diagnoses or behavioral health conditions that fall within the schizophrenia spectrum, including some that really may need to be considered if they're experienced in longer in duration or persistent in nature. The big one is, of course, schizophrenia or other psychotic disorders. There are some that are on this list that may not be part of the diagnostic criteria without the persistent and severe in nature duration. And then there are a couple that really don't meet the criteria unless they're accompanied by schizophrenia or other psychotic disorders. So I'm not going to read all of these. They're listed here. Again, we have information here that you can refer to later for more details. Certainly, when we think about working with folks who are justice involved, we do need to talk about substance use. There's an incredible comorbidity between schizophrenia and substance use. And so I do want to note that substance use alone does not meet care criteria. Certainly schizophrenia or psychotic disorders with comorbid, co-occurring substance use does meet criteria. So substance use alone, no. Schizophrenia with substance use, yes, that meets criteria. And again, well, not again, because we haven't talked about this, but substance-induced psychotic disorder or medication-induced psychotic disorder may meet criteria if the symptoms are persistent and ongoing and have impacted that person's functioning. One note about what can be included from a substance use treatment perspective is that substance use treatment can be included part of a care plan or care agreement, as can medications or medication-assisted treatment or medications for opioid use disorder. So we can think about things like bup or other meds can be included on that as well. Okay, let's go to the next slide. This looks like a lot. We have links for this as well. I am not going to go through this entire workflow of what the care process looks like, but I am going to just briefly say that if we consider the fact that on the left we have the initiation, again, there are multiple pathways into care. It could be through the county behavioral health agency. It could be through a petitioner. The process does begin when a petitioner files a petition, and so this is when we consider and refer to the individual as a respondent. The assessment and the engagement of the with the individual is conducted by the county, and then following that, we go into the actual court process. The entire process from start to finish, from the left side of the screen to the right side, is really about engaging people with services and with the opportunities to support their recovery over time. The process ends towards the right side of the screen, but for more information, do take a look at either our overview of the care process or the process workflow that you can find on our website. Okay, taking a look at time, I think I'm okay. So let's talk about court referrals to care. And here is when we have courts who are working with individuals who might benefit from a care petition. We have it broken out first into talking about courts that are working with people who have found incompetent to stand trial for misdemeanors, often referred to as missed here. In this case, the court can identify somebody who might benefit from care services. And that missed court would identify the person, make the referral to their county behavioral health agency, and the county would initiate the petition on behalf of the court. Important to note that here charges are dismissed after 6 months of engagement in care. I think specifically after 6 months from the referral to care, unless, of course, somebody is referred back to the criminal court before then. So that's the first way, missed to the county BH who's initiating the care petition on their behalf. I'm going to go out of order for a moment and just talk about AOT, assisted outpatient treatment, also Laura's Law. Going out of order here because this is also one that can identify somebody for a care petition or a care referral. And again, in this case, the AOT court is identifying somebody for care. And again, they're making that referral to their county BH agency. So very much like a missed court, they're also giving a heads up to the BH agency and asking to coordinate with a care petition. And then finally, LPS conservators. And so this is individuals who are either under conservatorship or have been identified as a potential consideration for care. This situation is a little different because here the conservator can file a direct petition to the court. The conservator court is the petitioner, and they're working with the court on behalf of the care respondent. Couple of notes. SB 42, Senate Bill 42, has now allowed for some communication between the courts. And so if they're working together collaboratively, AOT, LPS missed, they can talk about the status of a criminal case and the ongoing process for care while both cases are still pending. And then certainly they allow all parties to communicate, but it really does need to be part of the case disposition, and it's in court on the record. So we have links to some of those codes. We have recently done I think last week, we did a training on public guardians, public conservator referrals or petitions to the courts, and I think that will be posted on our website shortly. So if you'd like to know more information, please check out those trainings. And again, you can use the QA function here. We have some of our colleagues who are supporting responses in the background. Let's talk about a couple of ways in which justice providers or justice system, I shouldn't say providers because there's lots of folks, including attorneys in the courts, who may identify somebody and work to file a care petition. And these are very concrete steps that one can make. First is the petitioner. We've talked about conservator as a petitioner. We've talked about the individual as a petitioner, health providers, hospital providers who are working with people who are justice involved can all file petitions leading towards care proceedings. Really an opportunity to identify your court, which court in your county is accepting the petitions. You can either figure that out through your county's behavioral health agency or through the court. We may have a website as well. It's about then getting the papers, those the Care 100 and the 101 or other supporting information, filling them out. It can be done old style paper. It can be done electronically in most cases, and then filing those. Counties are doing it in different ways. Many counties are using e-filing. Some counties are just accepting hard copies. So it depends by the county how you file that petition. Important to note that there's no fees to file a petition. There's no cost to the petitioner. And then once the petition is filed, I want to note that the statute does say that the petitioner shall be present or the case may be dismissed. So we are hearing that, and it sounds like it's a best practice for the petitioner to at least come to the initial appearance to make a statement perhaps. And many counties are accepting remote appearances. Let me move on, I think, for time. So once that petition is filed, or you've worked with the county to file the petition, as I said, the petitioner should appear at the initial appearance. Once that happens, though, the county replaces the petitioner. And so after that initial appearance, the county steps in and they take over so that they can support the care proceedings. Justice system partners all throughout should consider not only serving as a direct petitioner, but serving as a referral to their county BH agency as well. Next slide, please. I'm going to take a breath and talk about this a bit. So certainly many of the folks that we are working with who are justice impacted have had some kind of trauma in their lives and continue to experience trauma just through being part of our system. And so I think it's really important that we think about ways that we could recognize an individual's trauma and not re-trigger them or not re-trigger a trauma. And so if there's an opportunity to understand the person's trauma history, that's a helpful thing. If you do have access to medical or psychiatric records, looking at that for history of trauma so that we can understand how this process could potentially impact the individual. And it reminds us to really maintain a trauma-sensitive approach. Certainly whenever possible, consider let's not re-traumatize the person. And we've done a lot of work with courtrooms, and certainly there's a lot of material out there to talk about how the courts can create an environment where we can reduce some of the re-traumatization. Maybe it's lighting, maybe it's showing pictures of the courtroom to somebody before they come in, or having a bailiff stand off at a different place, perhaps in the vision of the respondent. So lots of things that can be done on a concrete level environmentally to create or reduce a traumatic environment for the person. Certainly about being very clear about what's going on, explaining the process, breaking out the terms, breaking out the players who the respondent will be involved with, really explaining that this is not a criminal proceeding, it is a civil court process, and that might need to be reinforced a couple of times. The idea of that process is to ensure that services are provided. And part of that is not only explaining it, but involving the individual. What's important to you? What would you like to see in a plan? What language do you prefer? Do you want a peer involved or a voluntary supporter, somebody whose job it is to help ensure that your voice and choice are heard? Two roles that can be really helpful. And certainly using a strength-based approach, considering what's the person's strengths, what matters to them, what have we identified that shows that each of us have values that we bring to the table. And then certainly I'll mention, because we really need to talk about cultural humility. I don't know your experience, even though we may look the same or talk the same. That doesn't mean that I've walked in your shoes, or we look very different and I haven't walked in your shoes. So asking the questions, what does it mean for you to be part of this experience? Putting my bias aside and being present with the individual where they are, doing what I can to help create a guided and thoughtful experience. So I think I'm going to pause and take a breath because I may benefit from that. And we like to ask a question, and I'll pose it here for you. And then I think I'll probably respond myself. And just to take a moment to think about what are different ways or different pathways that the people you work with can access care. So when you're considering your clients, your patients, perhaps, what are different pathways that you can connect an individual to care? And so maybe jot that down while we're speaking or give some thought to it later. And certainly we've talked about court referrals, maybe AOT, LPS, MIST. That's one way or multiple ways that a court can refer to care. And then really considering all of the other people who were involved in the justice system, attorneys, providers. Those are all individuals who may be eligible petitioners or may be eligible referral sources, sending the information and working with the county to initiate a petition. So I'm going to pause. I'm going to turn it over now and I'm so pleased that we have some partners here who can talk with experience and expertise of what it means to actually see care services in their communities and to support that process. I'm on mute, aren't I? Judge Battier, thank you so much for joining us. I know you are busy this morning, so I really appreciate you taking the time. I'm going to mute myself and invite you to please come on.
Good morning, everyone. Thank you for giving me this opportunity to talk to you about care court and the impact of care court and the benefit of care court. I'm a judge in Orange County, and I handle and I preside over our care calendar. And I've been doing this since the implementation date of October of 2023. And really, I want to talk to you a little bit about the importance of making sure that when a care petition is filed with the court, especially when it's filed by a family member that may not be very comfortable completing court-related forms or have not done it before, we're trying to make the process as easily accessible as humanly possible. And the few areas that I want to share with you is the importance of making sure that you include in the petition all information that you have relating to your loved one, the respondent, that you're seeking to have help provided to them. A lot of time, information that may not seem on the face of it to be very important becomes very important to us to make the determination that this person is eligible or may be eligible to receive the services under the care court. And our objective is, even if we're not sure that somebody's eligible, as long as we can say that this person may be eligible for receiving the services, we are going to move the case within the process. If you have any information about any prior diagnoses, even if you don't have any documents, even if you were not present when that doctor provided the diagnoses, even if your loved one, the respondent in the past told you, I've been diagnosed with, and for care purposes, it needs to be schizophrenia-related diagnoses. Include that in the petition. Don't let the fact that you don't have a declaration from a doctor stop you from completing that petition and submitting that petition. That information becomes very, very helpful to us in assessing the eligibility of the respondent, and more importantly, in providing the services and kind of coming up with a plan that's going to give that respondent the highest likelihood of succeeding. The court pays a lot of attention to the observations that we make in court. So when the respondent is there and the way they're interacting with the team members, that's relevant. It gives us some insight into what that respondent is going through and what that respondent needs to be able to hopefully get on the right track as far as their mental health, to get the services that they need so that we can help them to be independent and be able to live a productive and independent life, even though they're suffering and dealing with this horrendous disease. The awareness about care court and the education relating to care court is very, very important, because there are a lot of people, and sadly and unfortunately, there are a lot of people out there that can benefit from the services of care court that they still may not know about the existence of care court. So educating colleagues, whatever entity you're with, whatever organization you're with, educating people within your organization is going to be very helpful about what care is about and about the services that it provides. The services that care provides, they're far-reaching. It doesn't just include, going to therapy or going to see a psychiatrist or going to see a therapist or a psychologist. It can include all aspects of services that individual needs to be successful. It includes medication. It includes getting them stabilized. It includes housing. It includes providing them with opportunities to learn more about their disease and be around people that can provide them with information that will allow them to be successful and get better and continue to get better. There is something very, very unique about care court when it comes to the justice system. The vast majority of cases that come before a judge in the justice system usually involve an allegation, at least, that somebody did something wrong. There is an allegation that somebody was engaged in some kind of conduct that is wrong that brings them before a court. Not in care court. There is zero allegation that anybody did anything wrong. Really, the purpose behind the process is to provide services for somebody that desperately need those services. So it's the purest form of non-adversarial proceedings in a court of law, because kind of everybody is kind of pushing and pulling in the same direction at the same time, which is to provide the services that the respondent needs to be able to deal with the challenges that come from a horrendous mental illness disease relating to schizophrenia. The benefit for care court doesn't just stop with the respondent. I see a lot of cases where you can tell the respondent is getting benefit and is getting services that they need. But I think within care court, it goes beyond that. It allows the court to be involved in letting the family members, the loved ones, the people that are in the community, even if the person is unhoused, the people that are in that same area that they are living with the person, it allows them to get a feeling that they're not in this alone. The fact that there is a group of professionals, including a judge, attorneys, mental health providers, healthcare agency providers that are on their side and they're trying to help them. So really the benefit doesn't stop with the respondent, it goes beyond the respondent. The respondent is the focus, is the one that we're mostly focusing on, always focusing on to give them those services, but it goes beyond that to provide help to the people that are trying to deal with somebody who is going through the challenges of dealing with schizophrenia. I hope this information is helpful. I appreciate everything that you all do to make this program successful. And if there are any questions, I look forward to trying to answer them for you.
Judge Bhatia, I want to say thank you so much. It's so meaningful to hear the empathy that you are bringing to this and taking that position of being supportive and non-adversarial and really considering the individuals and the communities. So thank you. We really appreciate not only that you're here, but what you're doing for the community.
It's my privilege. Thank you.
I am now going to turn it over, and I'm really pleased to have my colleague Raul Dominguez. He has this is, I think, the second time that he's joined us, maybe more by now. And he is from Stanislaus County, and he's going to tell us a little bit about his experience. And so also with great pleasure, I'm going to turn it over to you, Raul.
Good morning, everyone. Like Deborah said, my name is Raul Dominguez. I am a manager with the probation department here in Stanislaus County, and I manage our community assessment, response, and engagement team, which also is called CARE. But it is our homeless outreach team that goes out and engages people in the community who are unhoused and dealing with different types of issues, substance use issues, mental health issues. And those things are becoming a barrier for them to get into housing or just kind of continue their lives. So when Care Court first came into Stanislaus County, we kind of, since we already had a team that was dealing with some of these individuals, we kind of tapped in and started working with the Care Court team or the CARE Act team to get individuals into those type of services. So one of the things I want to bring up, especially with probation and some of the things that we had to clarify, probation and parole. So the CARE Act and Care Court, it is a civil matter. It's not a criminal matter. So when we were referring clients that were on probation to the CARE Act, some probation officers thought their cases were being transferred. It's not a transfer of a case. This is a whole different civil matter that's coming upon, you're bringing to the court with the petition. So the criminal case, the probation case will still be intact, and the probation officer is still case managing that case. But this new one, this new civil case will be going through the court, the Care Court kind of process, and then also receiving services from that team. So that's one of the things I just want to clarify. So it's two separate things, but it's all to help the individual. So as probation officers, we're trying to find some way to rehabilitate someone. This is just one extra tool to help you get those services. Some of the issues that we came across as we were dealing with some of these petitions were some that the judge brought up, not having some of the 5150 data, not having all of the actual diagnosis from the doctor. But one thing is, don't let that deter you from completing the petition. Complete the petition, get it into submitting it to the court. And even if you have limited information, that's still enough information to kind of keep the process going. A lot of times the behavioral health team that's managing the Care Court petitions, what they do is they start putting that information or finding out some of that information for you, and then including it with the petition to the courts as things move forward. So a lot of times, though, when you're dealing with individuals as probation officers, you get to know the individuals pretty well. So you get to see some of the issues that they have. So even though you may not be a mental health professional, you'll notice somebody who's responding to auditory hallucinations or maybe visual hallucinations, right? Or they're having these issues that you're just like, something's going on. This goes beyond just their behavior. They may have some mental health issues. And some of the things that we've encountered at the probation department is we start get individuals who their criminality is not so much criminal behavior. It's them having an untreated mental health issue or something that's going on beyond the fact that they're just out there committing crimes. Some of the other things we've encountered is we have a population who goes to court and sometimes they're incompetent to stand trial. So they really can't be held accountable for some of their actions because it's their mental health that's becoming the issue. So this has helped us a lot with those individuals. So one of the things I want to reiterate is, and keep reiterating, is submit the petition, even if you do not have all the information. Get as much information as you can that you have as the caseworker, case manager, and submit the petition to see what type of services they can receive. One of the benefits, I think, with probation is we do have a lot of collaboration with behavioral health, especially if you have like a mental health court or you may have, or a drug court, something like that in your communities. You already have that collaboration that you've built with behavioral health. Tap into those collaborations, keep working with them to find ways to get these petitions maybe done sooner or find some of the information that you can receive. As a probation officer, I know someone here brought up a release of information form. Many times when you're working with behavioral health, you already have those releases of information for your clients because you're getting update on the services that they're receiving for mental health. So I just encourage you to keep working those collaboratives, keep working with mental health to see what you guys can do to kind of facilitate the process, but also get as many individuals as you can into the CARE Act to receive the services that they need and hopefully get them rehabilitated and get them out of the situation that they're in.
Thank you so much. You said a couple of things that I just want to reiterate because I think they're meaningful both here and folks can take that take home message, which is even if you're not sure, you can submit because it's an additional tool in your tool belt. And I think that's so important. This isn't the only thing that you're offering an individual. It's what you're offering in addition to other services and supports. And so I appreciate that. Thank you. Thank you. So stick around because I know there's questions and we're going to be bringing you, Judge Battier, back. We had the opportunity to meet with another colleague, Polly Lynn, who is from Orange County, and unfortunately she wasn't able to join us today, but she had some really meaningful messages that we want to share with you, and she's given us permission to share some of her comments and some of her suggestions for best practice. Polly is a liaison where she's a liaison between the courts and the behavioral health in Orange County. And she talked with us about her advice, which includes identifying a liaison who could serve between both of the organizations as she does. It certainly makes sense that you have somebody who becomes the expert on not only care and legal proceedings, but the expert then on clinical and behavioral health matters as it's affecting the individual who has been identified for care. Some other suggestions are really keeping in touch with the client's attorney and with the court, taking the time to explain the process to the individual, maybe considering observing the individual who is either in a criminal or care court so that you can identify somebody's strengths and also kind of assess their understanding of what's happening, just more opportunities to engage the person and explain services, and then really just staying informed about that interaction between both. And she also shared with us some suggestions for petitions, is really understanding the various sources that can contribute to a care petition. Again, this is why she thinks it's helpful to have somebody who has both criminal and mental health backgrounds, including AOT or perhaps LPS. So some of the things that these individuals, these liaisons with this kind of experience might consider is using evaluations from county psychologists or forensic experts. And these could be things like, ATI or diversion reports or pre-conditional release reports. That could be brought into the petition as supporting evidence. And certainly these kinds of reports or this information can provide some diagnostic and historical treatment. And so if that's available, that can support the petition. And certainly coordinating with the providers in the community so that we can understand their perspective and their contribution to a petition. And whenever possible, to tap into if there is a liaison or a relationship to the petitioner's EHR or the county's EHR to tap into what kinds of material is available to complete a fuller and more robust petition. So some great advice from Polly, and I hope that we can have her back to speak live to us again. With that, I am going to ask my colleagues to come back on screen, and maybe the three of us so we can take a look at each other. I think would be meaningful. And after we talk a little bit about this, we're going to move over and hopefully try to answer some of the Q&A. And so Judge Battier, Raul, what advice, you've already given some, so I'm going to ask you again in a more condensed manner perhaps, but what advice do you have for professionals who are interacting with people who are justice impacted, justice involved, how they might consider participating in a care process? So what's like the big take-home advice that you would want to highlight from what you've just shared?
I think from my perspective, if you're dealing with somebody who's already involved in the justice system, so impacted by, and usually that usually comes into place when there is allegation of criminal conduct. The minute you start thinking about care, you got to put that criminal conduct completely aside. You can't let it impact or have an input into what you do. It's easier said than done. I realize that, because if you're dealing with somebody and you're reviewing a report that relates to the allegation of the criminal conduct, there is a place for it in the system, but not in care. In care, I think you need to be able to completely divorce yourself from the notion that this person is alleged to have done something criminal in a different arena. That may be true, and there is another process that's going to deal with it. But for the care process, you have to refocus your attention on the only objective behind the care process is to help somebody who's mentally ill, period. There is no asterisk. There is no qualifying aspect to it. The idea is to provide services for somebody who's mentally ill that needs these services.
So really thinking about the behavioral health needs as opposed to the behaviors that might have brought them to the courtroom.
Certainly. So, and sometimes the behavior that triggers the need for care is relevant, and you have to consider it, but not from a criminal perspective. You got to look at it from a, exactly.
That's lovely. Thank you. Raul.
I totally agree with what the judge said. I think it's really the hardest part of it also as criminal justice kind of partner law enforcement is to separate those both. But it's what you really have to do is be like, this isn't a criminal matter, this is a civil matter. And the main goal is to get this person the help that they need. As a probation officer, really that's what we're trying to do though, is help people rehabilitate their lives. So part of this rehabilitation is treating their mental illness. So looking at this as the added tool, like we said, plenty of times, to have this person treat their mental illness that they have not had treated for a while. And many times that's what's leading to their criminal behavior. Some of the crimes that they're committing is untreated mental illness. They're not in the right state of mind. They're hearing things. We get some of these clients that we refer to care court for vandalism, because they're hearing these voices or they're hearing things and they're damaging property, things like that. So a lot of times it's identifying what the kind of root cause of their criminal behavior is. And if it is this a mental illness, then it's getting them the help that they need. But like the judge said, it's two different things. It's really, this is a civil matter, and the focus is helping this person treat their mental illness. And it's not to hold them accountable for their criminal behavior. So it's really bifurcating both. I think that's the best thing you can do when referring to care court.
Tough to do, but what a wonderful opportunity to think about getting people connected to treatment rather than punitive actions. So, I hope that we've, through this hour, have encouraged some of the people who have joined us to make that same choice as you're making. And I thank you both so much for that. I am going to ask Patricia. I think that we have just a minute left, which means I've spoken a little long, but I'm going to ask Patricia to take us away.
I hope you enjoyed the discussion from our system partners and better understand care. Just as a reminder, the goal of this session was for you to have an increased ability to identify unique aspects of care, including those different paths through care and the range of services included, and also an increased ability to describe the role of the justice system as petitioners in the care process. We wanted to go over a few possible next steps for you. So we do have a number of trainings to learn more about schizophrenia spectrum and other psychotic disorders. We have one series that's meant for volunteer supporters, which is a lay audience, in case you felt like you needed a intro level training on schizophrenia spectrum disorders. And then we also have a series for county behavioral health. This could also be applicable to courts and council, and it provides some additional details and clinical information on schizophrenia spectrum disorders. So if you feel like those trainings would be helpful, you're more than welcome to visit those. Another training is learning about trauma-informed care and how to incorporate principles of trauma-informed care into our work. We have a 3-part series for behavioral health, also a 3-part series for the volunteer supporters or that lay audience. And we also have a training on mitigating implicit bias in the care process that could be useful to you. We also have a training on psychiatric advanced directives, and we thought that that could be helpful, especially for first responders or others involved in the justice system, to encourage potential care participants to work to complete a psychiatric advanced directive or a PAD. We do have a number of trainings and resources on our CARE Act Resource Center. So this is where you can go. You can click on, there's a QR code there, but if you want to get in touch of us or see what additional trainings there are, we have FAQs. You can connect to our listserv, submit TA requests, or of course, send us an email. On those trainings and resources page, at the very top, we have pinned resources, which can be helpful to people who are new to care. So you see both some resources at the top and then trainings on the bottom if you want more introductory information about the CARE Act and the CARE Act process. There are no wrong doors. So if you have a question and you don't know where to go, or you don't even know really what your question is, but you're looking for information, please go ahead and send us an email and we will get back to you and try to connect you with helpful information. Thanks again, and let us know if you have questions.